So, usually when we talk about a medical diagnosis, there's this underlying expectation of precision. It feels almost like engineering, right?
Right, yeah, like it's a hard science.
Exactly. You break your arm, the X-ray shows that jagged white line on the screen, and the doctor just points at it and says, there it is.
It's a completely binary system in our minds. It's either broken or not broken. It's just a clean, observable reality.
Yeah.
I mean, we find immense comfort in things that can be made visible and just neatly categorized like that.
But then you step into the wall of a courtroom. You step into the world of human events and trauma and conflicting motives, and suddenly that X-ray machine is just utterly useless.
Oh, completely useless.
We're looking at a diagnostic landscape of what actually happened in the past, and honestly, it is murky. It's really chaotic.
It is the absolute definition of diagnostic muddy waters. I mean, in a courtroom, you just don't have the luxury of putting the past under a microscope.
Right.
An event happens, and then it instantly vanishes into history. So to reconstruct it, you are relying entirely on fragments, human memory, scattered documents, digital footprints.
Human behavior.
Exactly.
And that actually brings us to the core of what we are doing today. So welcome, everyone, to today's deep dive. We are going to explore the invisible architecture of the justice system.
That's a fascinating topic.
It really is. And to do this, we're using a specific framework. We are looking through the lens of the Osmania University Law Syllabus. Specifically, Paper V Unit I, which is entirely dedicated to the law of evidence.
And the timing for this, honestly, couldn't be better, because that entire architecture just underwent a massive historic renovation.
A completely monumental shift.
It really is. I mean, for 150 years, the Indian justice system relied on the Indian Evidence Act of 1872.
1872.
Right. Just think about the world back in 1872. It was drafted by Sir James Fitzjames Stephen during the colonial era. We are talking about a world of inkwells, telegrams, horse-drawn carriages.
Wow, yeah, when you put it like that.
And now, that foundational text has been completely replaced by the newly enacted Bharatiya Sakshya Adhiniyam 2023, which we'll just be referring to as the BSA as we go.
Right, the BSA. And the mission for you listening today is to really unpack what truth actually means when you step before a judge. How does the system decide what to believe?
What are the actual rules of the game?
Exactly. What are the rules? By the end of this conversation, the precise methodology that dictates every single criminal and civil trial is going to make complete sense. So let's unpack this.
Let's do it.
The sources describe the law of evidence as an adjective law. Now, when I first read that term, my brain immediately jumped back to, middle school grammar.
Yeah.
Nouns, verbs, adjectives.
Naturally.
How does grammar apply to the justice system?
So it's a slightly older legal classification, but it's a really elegant one once you see how it fits into the broader machinery of justice.
Okay, I'm listening.
To understand adjective law, you first have to look at the two massive pillars that make up the rest of the legal system. So, substantive law and procedural law.
Okay.
Substantive law is the bedrock. It defines your rights, your duties, and what actually constitutes a crime. So if the law says theft is a crime, and it carries a penalty of up to 3 years, that is substantive. It defines the substance of human rights and wrongs.
It's basically the rule book for society. It tells me what I can own, what I can't steal, and what happens if I break those rules.
Correct, but a rule book isn't a machine, right? You need a way to actually enforce it.
Right.
That is where procedural law comes in. Procedural law dictates the step-by-step administration of justice. Like, how does a police officer make a lawful arrest?
Or how many days do they have to file a formal charge sheet?
Exactly. Which specific court building do you go to? All of that is the procedure.
So I was trying to come up with a way to visualize where this adjective law fits in. Because evidence doesn't really sound like a substantive right, but it also doesn't sound like a mere administrative timetable.
Somewhere in between.
Yeah. Let me try an analogy on you. Let's say we are baking.
Okay, I like baking.
Substantive law is the recipe itself. It tells you what a cake legally is and what ingredients are required to make it. Procedural law is the kitchen equipment. The oven, the timer, the measuring bowls. It's the environment where the baking happens.
I follow the logic so far.
So adjective law would be the actual cooking technique. It is the method of whisking, the temperature control, the way you prove to the judge that the cake is actually baked according to the recipe.
Oh, that's good.
It doesn't define the cake, and it isn't the oven. It is the methodology of proving the reality of the cake.
That analogy holds up beautifully, actually. Adjective law operationalizes the other two.
Mm.
It filters the chaotic reality of the outside world into a format that the court can actually digest and evaluate.
So it's the filter.
Yeah, it tells you whether you are even allowed to bring a specific ingredient into the kitchen and how much weight the judge should give to your baking technique. And what we are seeing with the BSA 2023 is a fundamental upgrade to these cooking techniques for the digital age.
Well, let's talk about those upgrades, because the shift from 1872 to 2023 is staggering.
It's massive.
The new BSA has 169 sections, replacing the old 167. They cleared out obsolete colonial holdovers and built in entirely new frameworks. But there is one change right at the beginning in the scope of the law that really caught my attention.
The territorial clause.
Yes. They deleted a single word. They removed the word India from the clause that dictates where the law applies.
It's brilliant.
That seems like a tiny typographical edit, but the implications feel massive.
The implications are completely transformative. By removing that one word, the legislature has fundamentally altered the territorial boundaries of evidence. Well, under the old 1872 Act, the application of evidence law was generally understood to be restricted to the physical territory of India. But if we consider the nature of modern crime, geographical borders are increasingly irrelevant.
Right, because if a syndicate is hacking into a bank account in Mumbai, the criminal doesn't have to be sitting in a van across the street.
Exactly.
The server could be in Iceland, the routing could go through the Cayman Islands, and the perpetrator could be sitting in a basement in Eastern Europe. The crime is entirely decentralized.
And under a strict 19th century geographical interpretation, gathering and admitting that evidence creates immense legal friction.
I can imagine.
So by omitting the word India from the applicability clause, the BSA makes a very deliberate statement. Electronic evidence collected outside the territorial boundaries of India is fully admissible in an Indian court. They're stripping away the geographical limitations of digital forensics.
It essentially means the courtroom is no longer just a physical room in a specific district. Its reach for evidence has gone global.
It really has.
And this ties perfectly into another major pillar of the new law, which is the flattening of the document hierarchy. Under the BSA, electronic and digital records now possess the exact same legal effect, validity, and enforceability as a traditional paper document.
This is a vital modernization.
Yeah.
For decades, courts wrestled with how to treat an email or a server log. Was it just a secondary copy of a quote-unquote real document?
Right.
The new law definitively says no. A WhatsApp message, a cloud storage log, server metadata. These are primary documents. They are not lesser forms of proof compared to a piece of paper signed with a fountain pen.
That's huge.
But of course, technology moves faster than legislation. To ensure the law doesn't become obsolete the moment a new technology is invented, the drafters did something quite clever with the definitions.
I noticed this in the framework. It doesn't actually try to define every single piece of tech. Instead, it links out to other laws.
Right. It creates a unified legal ecosystem. The BSA explicitly states that any words or expressions used within it that aren't specifically defined will automatically take their meaning from the Information Technology Act of 2000 or the new Foundational Criminal Codes.
And just for clarity for anyone listening, those new criminal codes are the BNS, the Bharatiya Nyaya Sanhita, which is the new substantive penal code replacing the old Indian penal code, and the BNSS, the Bharatiya Nagarik Suraksha Sanhita, which replaces the old procedural code.
Exactly.
So the laws are basically acting like software talking to each other. If the evidence law doesn't know what a blockchain hash or a digital signature is, it just queries the IT Act to get the current definition.
It keeps the evidence law lean, adaptable, and future-proof. But before a lawyer can utilize any of these modern tools, before they can bring in global server logs or digital contracts, they need raw material.
The facts.
Exactly. In the vocabulary of the courtroom, the raw material of reality is simply called a fact.
And this brings us to the anatomy of truth. We have to define what the ingredients actually are. And looking at the legal definition of a fact in the BSA, it is vastly broader than how we use the word in everyday conversation.
Oh, absolutely.
Usually when someone says fact, you think of something tangible and indisputable. The car is red, the table is made of wood, water boils at a specific temperature.
You are thinking of physical facts, things that occupy space and can be perceived with the 5 physical senses: sight, hearing, touch, taste, smell.
Right.
The law absolutely recognizes those. A blood stain on a carpet is a physical fact.
But the law goes way further than that. It explicitly includes any mental condition of which any person is conscious.
Yes, it does.
So a person having a specific intention or acting fraudulently or holding a certain opinion, those invisible psychological states are legally classified as facts. And here is the part that I found deeply counterintuitive. The law states that a person having a certain reputation is legally a fact.
It is a fascinating philosophical stance by the legal system. It recognizes that human reality is not solely constructed of atoms and molecules. It is also built out of intentions, perceptions, and social constructs.
That's wild.
Let's say you are on trial for fraud. The physical paper the contract is printed on is a fact, yes. But the most vital fact in that entire trial is the invisible mental state you held in your mind at the exact moment you signed it.
Did you intend to deceive?
Exactly. That invisible intention is a fact that the prosecution must prove exists.
It's wild to think of reputation as an objective fact, because reputation feels so inherently subjective. It's just what other people think of you.
I know, it sounds strange.
But I guess in the eyes of the law, the existence of that collective opinion in the community is a tangible thing that can be proven or disproved, especially in something like a defamation case.
Precisely. The court treats the public perception as a reality that has consequences. Now, once you accept that facts can be physical or mental, you run into a logistical nightmare. The universe contains an infinite number of facts. You cannot just dump a million random facts onto a judge's desk and ask them to sort it out.
That would be a mess.
The law has to impose structure, and it does this by dividing facts into two incredibly important categories: facts in issue and relevant facts.
Let's break these down because this seems to be the core navigation system for any trial.
You can think of the fact in issue as the ultimate destination of the trial. It is the bullseye. The textbook definition describes it as any fact from which a right, liability, or disability necessarily follows.
So in plain terms, it is the central question the court has gathered to answer.
Exactly. If we are in a murder trial, the fact in issue is agonizingly simple. Did person A intentionally kill person B? Every single thing that happens in that courtroom revolves around answering that one central question.
But you rarely have a situation where a witness just walks in, hands the judge the absolute answer to the fact in issue, and everyone goes home.
Very rarely. The reality of litigation is that you have to build a bridge to that destination. That is where relevant facts come into play.
The stepping stones.
Yes. If the fact in issue is the destination, relevant facts are the stepping stones. They are the ancillary surrounding facts connected to the main dispute that help prove or disprove it.
So sticking with our hypothetical murder trial where the fact in issue is did A kill B, a relevant fact might be that person A bought a highly specific poison a week earlier.
Right.
Or that person A owed person B a crushing amount of debt. Or that person A was seen running down the street away from B's house with blood on their clothes.
Those are perfect examples. Buying poison in a vacuum isn't necessarily illegal. It doesn't automatically mean you committed murder. But it is a stepping stone. It is logically connected to the central dispute. It makes the fact in issue, the idea that A killed B, more probable than it would be without that fact.
Okay, so the lawyers present all these stepping stones to the judge, trying to build a solid path, and then the judge has to look at this path and make a decision. The legal framework categorizes the judge's conclusion into 3 buckets: proved, disproved, and not proved. Now, proved and disproved seem fairly self-evident, but the standard the judge uses isn't what most people think it is it? We aren't talking about absolute mathematical certainty here.
We are not, and this is where many people completely misunderstand the justice system. The law relies on a standard based around a concept called the prudent man.
The prudent man. I love that. It sounds like a character from a 19th century novel. Who is this standard based on?
He is a legal fiction, basically a theoretical baseline. Section 2 of the BSA states that a fact is considered proved when, after considering all the matters before it, the court believes it to exist or considers its existence so probable that a prudent man ought, under the circumstances of that particular case, to act upon the supposition that it exists.
So the judge is essentially stepping outside of their legal robes and asking, if a reasonable, cautious, everyday person were looking at this pile of evidence, would they bet their practical life on this fact being true?
That is the exact mechanism. It is a standard of high, reasonable probability, not absolute, scientific infallibility.
Because if it were absolute...
If the justice system demanded absolute certainty, the courts would just grind to a halt. No one would ever be convicted of a crime, and no civil dispute would ever be resolved. A clever defense attorney can almost always manufacture some microscopic sliver of theoretical doubt.
Right, there's always a what if.
Exactly. The law doesn't ask for the elimination of all doubt. It asks if the probability is high enough that a careful person would act on it. And conversely, a fact is disproved when the court believes it doesn't exist, or its non-existence is so probable that our prudent man would act as if it didn't exist.
That leaves us with the third category, which I think is the most misunderstood. Not proved. My natural instinct is to assume that if the prosecution fails to prove something, it means the thing is false. It means it's disproved.
That is a very common logical leap, but legally it's incorrect. Not proved does not mean false, does not mean the event didn't happen.
What does it mean then?
It simply means the fact is suspended in a state of legal limbo. The party bearing the burden of proof failed to lay down enough solid stepping stones to convince the prudent man, but the opposing side also failed to bunk enough evidence to completely destroy the claim.
Wow, okay.
Fact just hangs there, unverified. It is a neutral state of insufficient data. The court is saying, we don't know, and therefore we cannot act on it.
Let me synthesize where we are so far. We have our raw ingredients, which are facts encompassing both physical objects and invisible mental states. We are trying to prove the main fact and issue by laying down a logical path of relevant facts. And the judge is using the prudent man probability standard to decide if that path is solid enough to walk on.
That captures the architecture perfectly.
But this immediately raises a massive logistical red flag for me. If a relevant fact is defined loosely as anything that makes the fact and issue more or less probable, where does it end? Couldn't lawyers just drag a trial out for decades? Imagine a defense attorney saying, "Your Honor, the defendant stubbed his toe that morning. That made him irritable, which fundamentally altered his brain chemistry, which makes it more likely he acted in sudden passion rather than premeditated murder." Could we just throw absolutely any logically connected stepping stone into the courtroom?
You've hit on the central vulnerability of pure logic, and you've perfectly transitioned us to the most vital gatekeeping mechanism in the entire law of evidence.
Okay, lay it on me.
The answer to your question is a resounding no. The law cannot afford infinite logic. It sets up strict, unforgiving barriers. And this brings us to the critical distinction between relevancy and admissibility.
Relevancy versus admissibility. Let's dig deeply into this, because reading the framework, this feels like the battlefield where cases are actually won or lost before a witness even speaks.
It is the ultimate battlefield. If you want to understand litigation, this distinction is paramount. Logical relevancy, which is covered in the early sections of the BSA, is based purely on common sense, human experience, and cause and effect. Does fact A make fact B more probable? If the answer is yes, the fact is logically relevant.
Like the stubbed toe example, it's a massive stretch, but if you trace the psychology, there's a tiny logical thread connecting pain to irritability.
Yes, the thread exists.
Yeah.
But the courtroom does not operate on pure, unrestrained logic. It operates on legal admissibility. Even if a fact is deeply logically relevant, the court might completely refuse to hear it.
Really? Why?
The law might statutorily restrict it.
Yeah.
Or it might violate a broader public policy, or it might breach a protected societal privilege.
I was trying to visualize this gatekeeping process. Tell me if this paints the right picture. Think of a major trial, like an exclusive VIP party at a nightclub.
Okay, I'm with you.
Relevancy means you have a logical reason to be at the party. Maybe you know the DJ, or you're friends with the host, or you helped pay for the venue. You are logically connected to the event. You are on the guest list.
I see where you're going with this.
But admissibility. Admissibility is the massive, intimidating bouncer standing at the front door. Even if your name is clearly printed on the guest list, if you show up violating a venue rule, maybe you're wearing sneakers instead of dress shoes, or you bypass the security line, or you're underage, the bouncer is going to put a hand on your chest and say, "Nope, you're not coming in." Your relevance doesn't override the rules of entry.
That is an incredibly accurate way to frame it. The golden rule of evidence law is this: all admissible facts are relevant, but not all relevant facts are admissible.
You have to get past the bouncer.
You must have a reason to be at the party, but you must also get past the bouncer. And the legal sources provide a very stark, historically significant example of this dynamic in action.
Yes, the rule regarding confessions made to police officers. Let's examine that, because it feels like the ultimate test of this gatekeeping theory.
Let's set the scene. Imagine a suspect is arrested for a major robbery. He is sitting in an interrogation room inside a police station. After a few hours, he completely breaks down. He looks directly at the investigating officer and says, "I did it. I robbed the bank and I buried the stolen cash in my backyard."
From a purely logical standpoint, that is the holy grail of relevant facts. The accused person literally verbalized their guilt to law enforcement. It is the ultimate stepping stone to the fact and issue.
Logically, it is overwhelmingly relevant. It doesn't get more relevant than a direct confession. But under the BSA specifically, Section 23, subsection 1, which carries forward the legacy of the old Section 25, a confession made to a police officer cannot be proved as against a person accused of any offense.
It's just thrown out.
It is strictly, entirely inadmissible. The bouncer at the door of the courtroom looks at that confession, sees that it was given to a police officer, and throws it in the trash. The judge is legally barred from considering it as evidence of guilt.
This is where I think a lot of people outside the legal profession get incredibly frustrated. Why? Why would the law intentionally blindfold the judge to a piece of evidence that seems so crucial? Why does this specific bouncer exist?
To understand the bouncer, you have to look at the history and the public policy behind the rule. This rule is deeply rooted in the realities of power dynamics.
Okay.
The law recognizes the immense inherent imbalance of power between an accused person locked in custody and a police officer controlling their environment. Historically and practically, it is an environment that is dangerously ripe for coercion, psychological intimidation, or outright physical violence, the infamous third degree used to extract a false confession just to close a case.
So the law is essentially saying, we recognize that a confession is logically relevant, but we fundamentally distrust the environment in which this specific piece of evidence was manufactured.
Precisely. The legislature had to weigh two competing risks. On one hand, you have the risk of excluding a completely true, voluntary confession made to a police officer. On the other hand, you have the risk of admitting a coerced false confession that was beaten out of a terrified suspect, which would poison the entire justice system.
Wow, yeah.
The law decided that the second risk is far more destructive to a free society. They enacted a blanket ban to remove the incentive for police to use coercion. The bouncer isn't there to hide the truth. The bouncer is there to protect the systemic integrity of the court from tainted evidence.
That is a profound philosophical choice. The law is choosing procedural fairness and human rights over pure, aggressive truth-seeking. It's a declaration that how the state arrives at the truth is just as important as the truth itself.
That is the essence of public policy and evidence law. You see it in other areas too, like privileged communication.
Like lawyer-client privilege.
Exactly. If you sit down in a closed room and tell your lawyer, I am guilty, I committed the murder, that statement is incredibly relevant. But it is entirely inadmissible. The bouncer blocks it because society has decided that the broader public good, allowing citizens to speak with absolute freedom to their legal counsel without fear of betrayal, outweighs the prosecution's need for that specific piece of logical evidence in one case.
Okay, so relevancy gets you on the guest list, and admissibility gets you past the bouncer and into the courtroom. Once the evidence is actually inside, what forms can it take? The framework categorizes evidence into three main buckets: oral, documentary, and circumstantial. Let's walk through these, starting with oral evidence.
Oral evidence is exactly what it sounds like. It is the testimony of a living witness, taking the stand, swearing an oath, and speaking to the court. But the BSA places a very strict foundational condition on oral evidence. It must, in all cases, be direct.
Direct can mean a lot of things. What does it mean in this specific legal context?
It means the court demands the original source of the sensory perception. If the evidence refers to a physical fact which could be seen, it must be the testimony of the specific witness who says, I saw it with my own eyes.
Okay.
If it refers to a fact which could be heard, it must be the person who says, I heard it with my own ears. You cannot take the stand and testify, my neighbor John told me that he saw the defendant steal the car.
Because that introduces the concept of hearsay.
Exactly. Hearsay is generally inadmissible because it breaks the mechanism of accountability. The court's primary tool for testing truth is cross-examination.
Right. You can't cross-examine a ghost.
Exactly. If you testify about what John saw, the opposing lawyer cannot cross-examine you about the lighting conditions or John's eyesight or John's angle of view. They need John in the witness box. The judge needs to observe John's physical demeanor, test his memory, and look him in the eye to apply the prudent man standard.
That makes total sense. But what happens when the original source simply isn't available? Are there exceptions to this strict rule against hearsay?
There are strict exceptions, born out of absolute necessity. The most famous and historically significant exception is the dying declaration.
Okay, walk me through that.
Let's say a person is fatally wounded in a dark alley. A bystander rushes over, and with their last breath, the victim whispers, My business partner stabbed me. The victim then passes away. Under normal rules, the bystander testifying to what the victim said would be hearsay.
Right, because the bystander didn't see the stabbing, they only heard the statement, and the defense can't cross-examine the deceased victim.
Exactly. But the law carves out an exception here. The bystander can testify to the victim's statement. This is based on a deeply held historical and psychological presumption, summarized by the Latin maxim, nemo mortuus presumitur mentiri. A dying man is not presumed to lie.
A dying man is not presumed to lie. Wow.
The legal philosophy is that when a person is facing imminent death, all worldly motives to fabricate a lie dissolve. The solemnity of the moment serves as a substitute for the oath and cross-examination. Plus, practically, if the court excluded it, many murders would go entirely unpunished simply because the only witness is dead.
It's a heavy, intense intersection of law and human mortality, so that covers the fragility and power of oral evidence. The second major bucket is documentary evidence. And as we discussed at the very beginning, under the BSA, this category has exploded to heavily include electronic and digital records.
It has. And the governing principle that rules all documentary evidence, whether it's a piece of parchment or a terabyte of server data, is known as the best evidence rule.
The best evidence rule.
Yes. The court operates on a simple premise. It always wants the best possible proof available. It doesn't want summaries. It wants the source. This brings us to the critical distinction between primary and secondary evidence.
Looking at the structure of the law, primary evidence is the gold standard. This means the original document itself is produced for the physical inspection of the court. So if two parties are fighting a massive civil suit over a commercial real estate contract, the primary evidence is the actual physical piece of paper containing the wedding signatures of both parties.
That is correct. The court demands the original because it allows for the highest level of scrutiny. With the original, forensic experts can check for microscopic alterations, forged signatures, different ink types, or physical tampering. You can't do that effectively with a copy.
But the real world is messy. What if I genuinely lost the original? What if my office flooded and the contract was destroyed, but I have a photocopy on my computer? Does my case just evaporate?
No, the law is pragmatic. That is when the court allows secondary evidence. Secondary evidence includes things like certified copies given by a public official or photocopies made from the original by a mechanical process that ensures exact accuracy.
Okay.
But, and this is a vital procedural hurdle, you cannot simply walk into court on day one, slap a photocopy on the table, and say, here's the contract.
Why not? If it looks accurate.
Because of the best evidence rule. You must first prove to the court's satisfaction why you cannot produce the primary evidence. You have to lay the groundwork. You must bring evidence to prove the office actually flooded, or prove that you searched diligently for the original and it is genuinely lost, or prove that the opposing party is maliciously hiding the original.
Ah, I see.
Only after you satisfy the judge that the original is truly unavailable does the bouncer step aside and let the secondary evidence into the room.
That is a brilliant safeguard. It prevents someone from maliciously photoshopping a contract, destroying the original to hide the tampering, and casually relying on a manipulated copy.
Exactly.
Now, the third categorization in our framework is the distinction between direct and circumstantial evidence. And I really want to dive into this because I think pop culture has completely warped our understanding of this concept.
Oh, completely.
For anyone listening who watches true crime documentaries, we are conditioned to believe that an eyewitness direct evidence is the absolute pinnacle of proof. And we are taught that circumstantial evidence means the prosecution has a terribly weak, flimsy case.
It is arguably the most pervasive Hollywood myth regarding the justice system. We are biologically and socially hardwired to believe what other human beings look us in the eye and tell us they saw.
Seeing is believing.
Right. Seeing is believing is a core human operating system. If a witness takes the stand, points across the room and says, I saw him pull the trigger, a jury or a judge naturally feels that the case is closed. But legally and practically, direct eyewitness testimony is often the most fragile and dangerous form of evidence.
That sounds completely backwards. Why is it fragile?
Because human beings are flawed, and human memory is not a video recorder. A single eyewitness can be bribed. They can hold a secret grudge. They can lie to protect someone else. But even more terrifyingly, and far more commonly, they can just be genuinely, innocently mistaken.
Just a failure of the brain's hardware.
Precisely. Think about the reality of a crime. It often happens in the dark. It happens in a matter of seconds. Adrenaline floods the brain, triggering a fight-or-flight response, which narrows focus. Decades of psychological research have proven that memory is highly malleable.
It's scary to think about.
The brain reconstructs memories. It doesn't replay them. An eyewitness can be completely confident, completely honest, and completely wrong. Eyewitness misidentification remains one of the leading causes of wrongful convictions worldwide.
So if direct evidence is that vulnerable to human error, how does circumstantial evidence compare? Because the phrase purely circumstantial is always used as an insult.
It really shouldn't be. Circumstantial evidence, when properly gathered and woven together, is profoundly strong. It is often much stronger than direct evidence. Circumstantial evidence requires the court to draw logical inferences from a web of interconnected facts. It doesn't directly, instantly prove the fact in issue, but it proves a multitude of relevant facts that point inevitably to only one logical conclusion.
Let's build a scenario to illustrate this. Let's say we have a murder trial with absolutely zero eyewitnesses. Direct evidence is non-existent. How does the circumstantial web work?
Let's build the web. Fact A. The prosecution proves the defendant purchased a highly specific, rare caliber of ammunition 2 days before the murder.
Okay.
Forensics proves the victim was killed with that exact rare caliber. Fact C. Investigators find the defendant's latent fingerprints on the inside of the victim's broken windowsill.
Is building up.
Fact D. Digital forensics, using the newly admitted electronic evidence rules, pulls cell tower data that places the defendant's phone exactly at the crime scene during the estimated hour of death. Fact E. Bank records and flight manifests show the defendant suddenly withdrew their life savings and booked a one-way ticket out of the country the very next morning.
Okay, I see the power of this. If you look at any single one of those facts in total isolation, a defense attorney could explain it away. Maybe he hunts with that rare ammo. Maybe he visited the victim's house a week prior to fix the window, leaving a fingerprint. Maybe he just decided to go on a spontaneous vacation.
Exactly. Isolated threads can be broken, but the court doesn't look at them in isolation. When you weave all those individual threads together into a tapestry, it becomes incredibly difficult to explain away as a mere coincidence.
It's just too much.
You might be able to bribe one eyewitness to point the finger at the wrong guy, but you cannot bribe the cell tower ping, you cannot bribe the fingerprint dust, you cannot manipulate the flight manifest, and you cannot alter the gun store receipt all at the same time.
The physical reality holds the narrative together.
Yes. A single thread might snap, but the tapestry holds the picture. The legal standard for a conviction based purely on circumstantial evidence is high. The chain of evidence must be so complete that it leaves no reasonable ground for a conclusion consistent with the innocence of the accused. It must point unerringly to guilt.
The tapestry holds the picture. That is a fantastic way to conceptualize it. And speaking of how different forms of evidence interact, there is a fascinating rule in the framework regarding how oral evidence interacts with documentary evidence. It's the exclusion of oral evidence by documentary evidence. How does that work?
This is essentially the legal system establishing a strict hierarchy of trust. The law is saying if you took the time and effort to formalize your agreement and write it down on paper, we are going to believe the paper over whatever words come out of your mouth later.
Makes sense.
If the terms of a contract, a grant, or a property disposition have been formally reduced to a document, no oral evidence can be admitted to contradict, vary, add to, or subtract from its written terms.
So, practically speaking, if you and I sign a highly detailed written commercial lease agreement that clearly states my rent is $5,000 a month, and a year later we end up in court over a dispute, I cannot bring my business partner to the witness stand to testify. Well, actually, Your Honor, before they signed, the landlord verbally promised it would only be $4,000.
Absolutely not. The bouncer steps in immediately and blocks that testimony. The written document reigns supreme. The rationale here is commercial certainty. If oral testimony could easily override written contracts would be entirely worthless.
It would just be chaos.
Every dispute would devolve into a chaotic he said, she said over verbal side agreements. The law forces parties to put their final intentions in the document.
Okay, let's take a collective breath here because we are really getting into the complex weeds of how a trial's reality is constructed.
It is a lot to take in.
We've defined the raw facts, we've navigated the bouncer of legal admissibility, we've categorized the evidence into oral, documentary, and the circumstantial web. But here is the next logical hurdle. How does a judge actually connect this vast web? How do they legally link a scattered series of actions together to form a coherent, admissible narrative?
The connective tissue.
Yes. The legal framework refers to this as the connective tissue, and it relies on some highly specific, deeply historical doctrines. Let's start with a Latin term that sounds incredibly intimidating. Res gestae.
Res gestae. It is a foundational concept in evidence law, and it translates literally from Latin as things done. The core doctrine states that facts which, though not directly an issue themselves, are so deeply connected with a fact and issue as to form part of the same transaction, are fully relevant and admissible.
Same transaction. That sounds like the language you'd use at an ATM. What does transaction mean in the context of human behavior and crime?
It means the entirety of the continuous event. The law recognizes that a crime isn't just a frozen split-second photograph of a trigger being pulled. A crime is a sequence of connected physical and psychological events occurring in a specific continuum of time and space.
So it's the whole scene.
Yes. Res gestae allows the court to zoom out from the freeze frame and admit statements or actions that occurred in the immediate heat of the moment, even if their statements would normally be blocked by the hearsay rule.
The legal sources highlight a few classic illustrations and major cases for this. For instance, a bystander shouting, "I did it!" right after a shooting. We established earlier that hearing someone else shout is hearsay. Why does res gestae allow it in?
It allows it in because of the psychological reality of the human brain. To fall under the protective umbrella of res gestae, an act or a statement must meet a rigorous test of spontaneity and contemporaneity.
Meaning it has to happen right then there?
It has to happen either exactly simultaneously with the main event, or so immediately after it, that the person making the statement simply did not have the cognitive time to concoct a lie.
Oh, I see the logic. If I am walking down the street, witness a horrific car crash, and immediately scream, "That red car just ran the red light," I'm speaking from a place of pure adrenalized shock. It's a reflex.
Exactly.
My higher cognitive functions haven't had the 3 or 4 minutes required to process the event, realize that the driver of the red car is my boss, and decide to lie and blame the blue car to protect him.
That is the exact underlying logic. Spontaneity bypasses the brain's lie generation center. It strips away the capacity for calculated fabrication. The law views these statements as the unfiltered raw truth of the moment speaking through the witness.
Wow.
The sources cite a very important Indian Supreme Court case, Sukhar v. State of UP, which reaffirmed this. In cases like these, if a witness arrives at the scene mere moments after a shooting, hears the victim cry out the name of the attacker and the victim dies, that statement is admissible. It is spontaneous, contemporary, and devoid of fabrication time.
The sources also mention a famous Privy Council case, Ratton VR, which involves a telephone call. That case always reads like a thriller to me.
It is a remarkable case that perfectly illustrates the doctrine. In Ratton, a woman was murdered in her home via a gunshot. The defense argued the gun went off accidentally while the husband was cleaning it. However, the prosecution found a switchboard operator who had received a call from the house merely moments before the time of death. The operator testified that she heard a woman's voice, hysterically sobbing, screaming, "Get me the police, please," before the line suddenly went dead.
And naturally, the defense team tried to block the operator's testimony by calling it hearsay. They argued the operator didn't see the murder, she just heard words on a phone.
Exactly. But the Privy Council admitted the operator's dramatic testimony under the doctrine of res gestae. They ruled that the hysteria, the desperate tone of voice, the specific timing of the call, seconds before the gunshot, all of it was an integral, inseparable part of the transaction of the murder.
It's the context.
It wasn't a calculated narrative about the past.
Yeah.
It was a real-time, involuntary reaction to an ongoing attack. It proved she was in a state of terror, which completely dismantled the accidental shooting while cleaning the gun defense.
That is chilling, but logically, it makes perfect sense why a court seeking the truth absolutely must hear that testimony. It is the connective tissue of the immediate moment. But what about the tissue-connecting events that happen days before or weeks after the crime? The framework moves us to Section 8, which deals with motive, preparation, and conduct.
If res gestae is the heat of the moment, Section 8 is the court looking at the long game. It establishes that any fact is relevant, which shows or constitutes a motive or preparation for any fact in issue. Furthermore, the conduct of any party, either before or after the event, is highly relevant if it influences or is influenced by the central event.
Let's use the classic poison illustration. If Person A is on trial for the murder of Person B by Poison 8,
Under Section 8, the fact that A secretly purchased a specific lethal poison 2 weeks before B's death is highly relevant. That is preparation. It shows a forward-looking design. It changes the narrative from a sudden accident to a calculated plan.
And what about conduct after the fact? What if the crime is already complete?
Conduct after the fact is often the most revealing. If, immediately following B's death, Person A packed their bags, withdrew all their money from the bank in cash, and fled the city using a forged passport that is subsequent conduct.
Because an innocent person wouldn't do that.
The law operates on the reasonable assumption that an innocent person usually stays and cooperates with the authorities to clear their name. Flight, the concealment of physical evidence, or attempts to intimidate witnesses are all pieces of conduct that strongly suggest a guilty state of mind.
So for anyone listening who might ever find themselves sitting on a jury, the law is explicitly giving you permission to look at the entire narrative arc of a person's behavior, not just the isolated freeze frame of the crime.
Absolutely.
But let's flip the perspective. What if the defendant wants to use this connective tissue to definitively prove their innocence? The sources mention Section 11, titled Facts Not Otherwise Relevant, which introduces a concept known as the plea of alibi.
The plea of alibi is arguably the strongest defense mechanism available in criminal law. Alibi is simply a Latin word meaning elsewhere. Section 11 dictates that facts, which are normally completely irrelevant to a case, become highly relevant if they are absolutely inconsistent with the fact in issue, or if they make the existence of the fact in issue highly improbable.
Give me a concrete scenario of how a normally irrelevant fact shatters a case.
Let's say person A is accused of brutally murdering person B in a house in New Delhi on a Monday at precisely noon. The prosecution presents their circumstantial web. Then, the defense introduces a new fact. Person A was attending a highly publicized crowded industry conference in Mumbai on that exact same Monday at noon.
That's a strong alibi.
They present video footage of A on a stage, hotel receipts, and 20 reliable witnesses who spoke to A in Mumbai at the time of the murder.
Now, fundamentally, being at a conference in Mumbai has absolutely nothing to do with the murder in New Delhi. They are separate events.
Exactly. In any other context, A's trip to Mumbai is completely irrelevant. But in this specific trial, the physical reality of A being in Mumbai is absolutely physically inconsistent with the fact and issue that A was in New Delhi committing a murder. Because humans cannot be in two places at once, the alibi becomes supremely relevant.
It just destroys the prosecution's case.
It doesn't just chip away at the prosecution's web, it takes a sledgehammer to the entire timeline.
It's the ultimate web breaker. Okay, we have one more crucial piece of connective tissue, state of mind or intent, which relates back to our earlier discussion about psychological facts. How do you actually prove what is invisible? How do you prove what's inside someone's head?
You prove the invisible by illuminating patterns of the visible. The law states that facts showing the existence of any state of mind, such as intention, knowledge, good faith, or ill will, are relevant. And the most effective way prosecutors prove this is by showing a series of similar prior occurrences to prove that the current act was deeply intentional and not just a terrible, unfortunate accident.
The legal sources have a wild illustration for this regarding a serial arsonist and insurance fraud.
It is a textbook example of proving intent. Imagine a man, let's call him A, whose house burns to the ground. He files a claim stating it was a tragic electrical fault and attempts to collect the massive insurance payout. In isolation, that could very well be a genuine, heartbreaking accident.
Sure, fires happen.
But the prosecution starts digging. They introduce evidence that A previously lived in 3 other houses over the last 10 years. He heavily insured every single one of them. And every single one of those houses mysteriously burned down under similar circumstances, resulting in A collecting insurance money from different companies every time.
That is an astonishing coincidence.
And that is exactly the point. The prior fires don't directly prove that he struck the match on this specific house.
Right.
But they show a behavioral pattern that makes the tragic accident defense statistically and logically absurd. They establish a fraudulent state of mind and a systematic design. The repetition is the proof of the intent. The judge uses the pattern to see inside the mind of the accused.
This is truly fascinating. When you lay it all out like this, a trial is basically a giant high-stakes jigsaw puzzle. And the judge is the one piecing together the timeline, the physical actions, the mental state, the escape.
It's a huge task.
Okay, but here's a practical thought that comes to mind. The judge is a human being. Evaluating all this complex human behavior, parsing through circumstantial webs, listening to competing experts, it seems incredibly taxing and time-consuming. Does the judge always have to start from absolute zero in every single case? Do they have to mathematically prove every single tiny foundational fact, like proving that the sun actually rose that morning?
That is an excellent practical question, and it transitions us beautifully to our final major segment, the weight of the gavel. The answer is no. The judge does not always start from absolute zero. The legal system recognizes that it needs efficiency to survive. Therefore, the law provides built-in judicial shortcuts designed to save time, reflect common sense, and establish order.
Shortcuts, okay?
In evidence law, these shortcuts are called presumptions.
Presumptions. Okay, looking at the legal framework, there are 3 distinct tiers of these shortcuts. May presume, shall presume, and conclusive proof. Let's start at the foundational tier. What exactly is a may presume scenario?
May presume is entirely discretionary. It means the court can accept a certain fact as true without demanding formal, agonizing proof, but is not legally forced to do so. The judge can use their own discretion based on the unique circumstances of the case.
Interesting.
If the judge chooses to use a presumption, they can accept it as fact until it is disproved by the opposing side. Alternatively, if the judge feels suspicious, they can refuse the shortcut and demand actual proof.
Can you give me a practical example of when a judge would use this?
A classic example involves older documents. Imagine you are in a property dispute, and you produce a land deed that is proven to be 30 years old. Finding a witness who was in the room 30 years ago to authenticate the signature is going to be a nightmare.
Yeah, they might be dead, or their memory might be entirely gone.
Exactly. So the law gives you a break. If the 30-year-old document comes from proper custody, like a secure family archive or a government vault, the court may presume that the signature and handwriting are genuine and that it was properly executed.
It's a pragmatic shortcut because demanding perfection from a 30-year-old piece of paper is impossible.
Exactly. But it is rebuttable. If the opposing lawyer stands up and says, "Wait a minute, Your Honor, the ink on that supposedly 30-year-old deed looks brand new,
Yeah.
and the paper is modern printer paper. We think it's a forgery."
Okay.
The judge can instantly drop the presumption, agree with the suspicion, and say, "Okay, the shortcut is over. Bring in a forensic ink expert and prove it's real."
I see. The judge has the wheel. Okay, stepping up to the next tier. What happens with shall presume? Because changing the word may to shall sounds like a massive shift in judicial power.
It is a significant shift. Shall presume completely removes the judge's discretion. When the law applies this standard, the court must presume the fact is true. It is a mandatory starting point.
Wow, okay.
However, it is still rebuttable.
Yeah.
The court must accept it as fact unless and until the opposing party brings sufficient evidence to disprove it.
So it essentially shifts the burden of proof onto the other side. You get a massive head start.
Precisely. Let's look at the rules regarding powers of attorney. If you present a power of attorney document that is formally authenticated by a notary public or a court judge, the court shall presume it was properly executed and authentic.
So the judge can't just doubt it.
No, the judge cannot look at it and say, "I'm personally a bit suspicious of this notary stamp. I want you to bring the notary in to testify." The law commands the judge to accept the document at face value.
But the opposing side can still fight back.
Yes, the door is still open. The opposing counsel can say, "We accept the stamp, but we have medical records proving that the person who supposedly signed this power of attorney was in a medically induced coma on that specific date." If they prove the coma, the presumption is shattered. It's a strong legal shield, but it is not impenetrable.
Which brings us to the top of the mountain, the final boss of evidence law, the third tier, conclusive proof.
Conclusive proof is the most absolute, unyielding standard in the entire law of evidence. It is an irrebuttable presumption. When the law formally declares fact A to be conclusive proof of fact B, the court must accept fact B as the absolute truth.
Okay.
And here's the profound kicker. The court cannot allow any evidence whatsoever to be given for the purpose of disproving it.
Wait, I have to stop you there because my mind is fundamentally rejecting this concept. You're telling me the court intentionally legally blinds itself. Even if someone walked into the courtroom with a mountain of irrefutable modern scientific evidence to dispute the fact, the judge's hands are totally tied. They have to plug their ears and say, "The law says it's true, so we are moving on."
That is exactly what I'm saying. It represents absolute, unshakable finality.
You have to give me an example of this because on its face that seems almost anti-truth. It seems to go against the entire mission of the justice system we just spent an hour discussing.
It is a jarring concept, I know, but it makes sense when you look at the philosophy. The most famous historical example is found in the rules regarding the legitimacy of children, a concept codified in Section 112 of the Old Act, which conceptually persists in the jurisprudence of evidence.
Okay, lay it out for me.
The rule essentially states, if a child is born during the continuance of a valid marriage between a mother and a man, or within 280 days after the dissolution of that marriage, the mother remaining unmarried, that fact is conclusive proof that the child is the legitimate offspring of that man.
So, let me get this straight. Even if the husband comes into court and says, look, I have a state-of-the-art DNA test from the world's best laboratory that shows with 99.99% scientific certainty that I is not the biological father, the court won't even look at the DNA test.
Unless the husband can prove an extremely narrow physical exception, specifically that he had absolutely zero physical access to the wife during the entire possible time of conception. For example, he was deployed on a submarine for a year. The general historical rule was that the court would completely refuse to entertain the challenge to legitimacy.
The DNA test just gets blocked at the door.
The DNA test will be stopped by the bouncer at the door. The legal status of legitimacy was conclusive. Now, I will add the caveat that modern constitutional jurisprudence and the sheer undeniable reality of DNA testing are currently creating immense, unprecedented pressure on this specific 150-year-old rule, and modern courts are actively wrestling with how to adapt it.
I would hope so.
But as a pure foundational evidentiary concept, that is exactly how conclusive proof operates.
But why on earth would the law design a mechanism like that? It feels profoundly unfair to the individual husband in that scenario. Why prioritize a legal fiction over biological reality?
Because the law is not just a microscope, it is a vital pillar of society. The law is constantly balancing the rights of the specific individual against the broader stability of society. Why would a court intentionally blind itself? For the sake of public interest, ultimate finality, and legal certainty.
So in the legitimacy example, it's basically to protect the child.
Exactly. The architects of the law decided, as a matter of strict public policy, that it is far more damaging to society as a whole and deeply irreparably traumatizing to innocent children to allow endless, messy, spiteful litigation over who is legally legitimate and who is deemed a quote-unquote bastard in the eyes of the state.
It's about protecting the vulnerable.
The law essentially says we need a definitive, unbreakable endpoint for the sake of social order. If you are married, the child is legitimate. End of discussion. We are not opening Pandora's box.
It's the ultimate trump card. And I imagine this applies to massive legal rulings too, right?
Yes, it heavily applies to what we call judgments in rem. These are judgments that declare the legal status of a person or a thing against the whole world, not just between two people fighting over a contract. For example, a formal divorce decree from a competent court.
Okay, how does that work?
If a judge officially declares you divorced, that document is conclusive proof of your new legal status globally. You can't have someone randomly sue you 5 years later claiming your new marriage is invalid because your old divorce was technically flawed. The status is conclusively settled for the sake of societal order and peace.
Wow. This entire conversation has really highlighted how the law is this massive, intricate balancing act. It is constantly oscillating between finding the granular, objective truth of a single moment and maintaining a functional, peaceful society.
That's a great way to put it.
Sometimes it aggressively prioritizes the exact truth, like when it enforces the best evidence rule to demand an original document. And sometimes it openly prioritizes societal stability, like when it uses conclusive proof to protect a child's status or bans police confessions to protect human rights.
That is the perfect encapsulation of the adjective law. It doesn't just seek the truth. It regulates exactly how the truth is digested by the state.
All right, let's take a step back and look at the sheer distance we've covered on this journey through the architecture of evidence. Think about how far we've traveled from that initial medical X-ray metaphor. We started with the raw ingredients, the facts, acknowledging the mind-bending reality that a human intention or a public reputation is treated just as seriously as a physical weapon.
We examined how those facts are ruthlessly filtered. They have to be logically relevant, a solid stepping stone to the ultimate fact and issue. But even then, they have to survive the intimidating bouncer of legal admissibility.
We looked at the different forms this evidence takes. We saw the inherent fragility of human oral testimony versus the ironclad weight of original documentary evidence. We dispelled the Hollywood myth and learned why circumstantial evidence isn't a weak link, but a complex, nearly unbreakable, woven tapestry.
And we explored the connective tissue that holds that entire tapestry together. The spontaneous, unfiltered truth of res gestae, the psychological footprints left by motive and subsequent conduct, and the timeline-shattering power of a solid alibi.
Finally, we felt the heavy weight of the judge's gavel. We saw how the system uses presumptions to streamline trials and protect the fabric of society. It truly is a brilliant, intricate machine. But before we sign off today, there's one final lingering thought that I can't quite shake, and it builds on everything we've discussed about the modernization of these rules.
What's on your mind?
We started this deep dive by talking about the transition from 1872 to the Bharatiya Sakshya Adhiniyam of 2023. We praised how it brings the law into the digital age. It aggressively expands the inclusion of electronic evidence. It treats global server metadata, cloud storage, and digital footprints identically to physical paper.
Yes, it is a vastly necessary modernization for a decentralized world.
But is it possible that it is already completely out of date? Think about it. This entire magnificent 150-year-old system relies fundamentally on the prudent man standard, a reasonable, everyday person looking at the evidence, a photo, a video, a document, and deciding if it's probable. But we are currently standing on the precipice of an era driven by generative artificial intelligence.
You were talking about the deepfake crisis.
Yeah. Exactly. For centuries, the ultimate trump card of oral and documentary evidence was seeing is believing. If I play a high-definition video in court of the defendant committing a crime, the prudent man standard naturally says, well, there he is on tape. Case closed. But in a rapidly approaching future where an AI model can generate a hyper-realistic, completely synthetic video of anyone doing anything, a video so perfect that it can fool even sophisticated digital forensics, what happens to the best evidence rule?
It raises a terrifying, existentially fascinating question for the legal profession. When a digital document or a video file can be fabricated from thin air with a simple text prompt, will our current definitions of documentary evidence survive? Will the bouncer at the door of admissibility even know how to check the ID of a synthetic reality?
If the very nature of audio and video can no longer be inherently trusted, does the prudent man have to evolve into a paranoid man? Will the legal system have to completely redefine what constitutes conclusive proof in a modern courtroom where your own eyes and ears can be mathematically perfectly deceived?
The BSA 2023 was masterfully built to solve the problems of the internet age. But the AI age might require an entirely new, radical philosophy of truth altogether.
And that is something for all of you to deeply ponder the next time you see a shocking video online or sign a digital contract. The architecture of truth is brilliant, but it is always shifting under our feet. Thank you for joining us on this deep dive into the machinery of evidence. Until next time, keep questioning what you see.